Ms. Bagley, will you please swear the defendant in?
Sure. Will you please raise your right hand? Do you swear or affirm the testimony about to give the truth, the whole truth, and nothing but the truth, help you God?
Yes, ma'am.
Thank you.
All right, Mr. Smith, you are here facing two separate charges that have been filed against you. First charge is murder in the third degree. That is a first-degree felony under Florida law, and it carries up to a maximum of 30 years in prison as a possible sentence. Count two is possession of a weapon or ammunition by a juvenile delinquent. In other words, someone who has been previously convicted as a juvenile of what would otherwise be a felony if it was an adult charge. That's a second-degree felony, and it carries up to a maximum of 15 years in prison as a possible sentence. Are you aware of the two charges that have been filed against you, sir?
Yes, sir.
You understand the maximum sentences you could receive if you were found guilty of either charge?
Yes, sir.
Additionally, if you are found guilty of both of these charges, you have a guideline score of 148.5 months in Florida State Prison. Were you aware of that, sir?
Yes, sir.
That's a guideline score of a little over 12 years. It's 12.375 years as is a guideline score. You understand that?
Yes, sir.
So you understand also that the guideline score is most likely the minimum sentence that this court can impose if you are sentenced as an adult rather than a youthful offender or a juvenile.
Yes, sir.
And so if you were sentenced as an adult and not a youthful offender or a juvenile, you are facing a sentencing range of 148.5 months all the way up to 30 years if the court were to sentence you concurrently on all of these charges, but technically could all the way go up all the way to 45 years if the sentences were run consecutive. Do you understand that?
Sir.
Go ahead. So you need to repeat your answer.
Yes, sir.
Yeah, someone shut a door behind you and it blocked what you said. Okay, so you understand that that's the sentencing range as I just explained it.
Yes, sir.
All right, your attorney has indicated you wish to enter a plea of guilty to both of these charges this morning. Is that what you want to do?
Yes, sir.
Have you spoken with your attorney about these charges?
Yes.
Have you gone over the state's evidence with her in this case?
Yes, sir.
You've been able to fully discuss your case with your attorney, including any possible defenses?
Yes, sir.
And have you gone over the sentencing range with her?
Yes, sir.
Has she answered all of your questions to your satisfaction?
Yes, sir.
Do you have any further questions of your attorney about anything before I proceed forward?
No, sir.
Is there any further investigation you feel your attorney needs to do in this case that she hasn't already done?
No, sir.
Is there anything else you feel your attorney needs to do in this case on your behalf that she hasn't already done?
No, sir.
Are you satisfied with her representation in this case?
Yes, sir.
And if I accept your plea here today, what will take place is I will pass your case for a sentencing hearing. And at that sentencing hearing, I will consider whether or not to sentence you as a juvenile, sentence you as a youthful offender, or sentence you as an adult where the guidelines are in play of 148.5 months all the way up to 30 years or 45 years consecutive. You understand that?
Yes, sir.
You understand that while I can't sentence you as a juvenile or a youthful adult, a youthful offender, there is no guarantee that that will occur.
Yes, sir.
You understand that you can be sentenced as an adult and be a convicted felon as an adult by entering a plea here today.
Yes, sir.
You also understand while you will have the opportunity at the sentencing hearing to present evidence and argument as to why this court should go below the 148.5 month guideline sentence, even if I sentence you as an adult, you understand that there's no guarantee that the court, number one, will have the legal ability to do so, and number two, the court that still may not wish to do so based on the evidence. Do you
Yes, sir.
understand that? So in other words, what I'm trying to tell you is you can still, even if I sentence you as an adult, you will be able to argue for a downward departure below the guideline score. But do you understand there's no guarantee that you will get that?
Yes, sir.
Has anyone promised you anything to get you to enter your pleas here today?
No, sir.
Has your attorney guaranteed you any specific sentence to get you to enter your pleas here today?
No, sir.
Has your attorney guaranteed that this court will impose a youthful offender sentence in this case?
No, sir.
Has your attorney guaranteed you or promised you that this court will impose a juvenile sentence in this case?
No, sir.
Has your attorney guaranteed you or promised you that this court will impose an adult sentence below the guideline score?
No, sir.
Has the state attorney promised you anything whatsoever to get you to enter your plea here today?
No, sir.
All right. Has anyone threatened you, forced you, or coerced you in any way to enter your pleas here today?
No, sir.
Have you taken any medication today?
No, sir.
Are you under the influence of any alcoholic beverage or any drug right now?
No, sir.
Can you read and write?
Yes, sir.
At some point, did your attorney give you a form? It's titled Plea of Guilty and Negotiated Sentence.
Yes, sir.
Okay, and even though there's not a negotiated sentence in this case, it's still the title of the form. And you received that form?
Yes, sir.
Did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you entering pleas of guilty to both of these charges because you believe you are in fact guilty of both crimes?
Yes, sir.
If I accept your pleas here today, you waive certain rights that you are guaranteed under the Constitution. Those rights include the right to a trial, the right to a jury trial, the right to counsel at all critical stages of the case, including trial, the right to call witnesses to testify for you, the right to cross-examine state witnesses that testify against you, the right to remain silent at all times, including the trial, the right to require the state to come to trial and prove your guilt beyond a reasonable doubt. And finally, if you went to trial and you weren't satisfied with the result, you'd have the right within 30 days to appeal any and all issues to a higher court. Do you understand you have all of these rights?
Yes, sir.
You understand by entering your pleas of guilty here today, you are waiving each and every one of these rights.
Yes, sir.
All right. Any questions about your constitutional rights?
No, sir.
Currently, how old are you, sir?
18.
What's the last grade or level of education you completed?
9th grade.
Okay. Do you have a GED degree or a high school equivalency diploma?
No, sir.
All right, but you can read and write.
Yes, sir.
You were able to understand you were able to read and review the discovery and understand that and talk about that with your attorney.
Yes, sir.
All right, if you enter pleas of guilty to these charges and you are not a U.S. citizen, you will be deported from this country. Do you understand that?
Yes, sir.
Knowing that, do you still wish to enter your pleas?
Yes, sir.
If in the past you have been convicted of a crime that would be considered a sexually motivated or sexually violent offense under Florida law, you risk the possibility of sanctions under what's called the Jimmy Rice Act if you enter your pleas of guilty today. Those sanctions can include involuntary civil commitment for an indefinite period of time once you complete whatever term of incarceration I impose in connection with these two charges. Now, again, that potential sanction is only relevant if you have been convicted of a sexually motivated or sexually violent offense in the past. Do you understand that, sir?
Yes, sir.
Knowing that, do you still wish to enter your pleas?
Yes, sir.
Is either side aware of any DNA evidence that would exonerate this defendant on either charge?
None known to the state.
Unknown to the defense.
Was there even any DNA evidence involved in this case?
No, sir.
No, sir.
All right, the state wish to proffer a factual basis for both charges.
Yes, sir. Should this case go to trial, the state would be prepared to prove beyond a reasonable doubt that this defendant on February 24th of 2020 in Nassau County, Florida, did unlawfully, but without any design to effect death, while engaged in the perpetration or attempt to perpetrate sale or delivery of controlled substance, kill Trent Fort, a human being, by shooting him. And during the commission of this murder, the defendant did carry, display, use a firearm, that being a pistol. And further, this defendant at the time was under 24 years of age and did have in his care, custody, possession, or control a firearm, that being the pistol, having previously been found to have committed a delinquent act that would have been a felony if committed by an adult, that being burglary, in the Circuit Court for Alachua County, June 27th, 2018.
Any objections or exceptions to the factual proffer, Ms. Jameson?
No, Your Honor.
Mr. Smith, you've heard the state outline the evidence they're prepared to present in support of both of these charges. Do you accept the state's factual proffer, sir?
Yes, sir.
Based on the proffer, the court finds there is a factual basis for this charge. Anything else, counsel, that I need to address in the plea colloquy before I proceed to the next stage?
I don't think so, Your Honor.
No, Your Honor.
All right. This time, the court also finds that the pleas of both charges have been given freely and voluntarily. We're going to stop real quick. Deputy, can you make sure that whoever's back there, please stops talking?
Yes, sir.
I mean, they need to, if it's particularly if it's other deputies, they need to understand that it's interfering with the plea. All right. Again, I'm going to start over because and I'm going to find that the pleas of guilty to both of these charges have been given freely and voluntarily with a full understanding of the nature and consequences of the pleas. The court makes those findings and the court will now accept both of your pleas and we will pass your case for sentencing and we'll talk about a date in just a minute. I do though, Mr. Stevenson, we need to order I assume we need to order a PSI. I assume he's never been convicted as an adult felon. And so, but also I do need for someone to reach out to DJJ and also order a predisposition report because he is entitled to have both in this sentencing hearing. And so I don't know, Madam Clerk, can you handle that or does Mr. Stevenson, you handle that?
I can handle that, Your Honor.
Whoa, but if you both do it, then there'll be some redundancy there and we'll hopefully they'll get it done. So thank you. So with that, we need to talk about sentencing hearing. I know that it could, you all can coordinate with my office if you need to for a time certain outside of today's hearing. But I think that at minimum we're talking about at least 4 weeks. So I mean, at minimum, and that would be so that you can get the PDR and PSI back. So I don't think this would be ready for sentencing hearing until October 28th. Are there any other considerations taken into account in scheduling?
Your Honor, I do have an expert. I have some of his availability for the end of October and the first part of November. After that 28th date that you just announced, he is available 10/29 and the week of 11/15 is what he's given me thus far.
All right, well, let's do this then. I mean, 10/29 is actually could potentially be a jury selection day because we've got trial week November 1st. If I didn't have a jury to pick that day, the 29th would actually work really well. And I don't know that I will or I won't at the early juncture. So let's do this. I am going to schedule, right now, let's do this. I'll schedule the sentencing hearing. I'll schedule it for 10:29 right now, okay? What I would like to do though is also put him on the docket for a status hearing on October 28th, okay? Because that way we can talk about whether it's going to go forward or not on the 29th. And at what time? Because there may need to be some flexibility on the time. I mean, I might be able to pick a jury on that day, and then have the sentencing hearing later in the afternoon. And there needs to be some flexibility, but I think we could probably get the sentencing hearing done one way or the other, 29th, and giving both state and the defense attorney enough time and notice to figure out, to get everybody here that they need to get here. Okay.
Your Honor, would you allow my expert to testify via Zoom? He lives out of our area, and that would certainly, be a consideration that I think would guarantee, we can make it happen as scheduled rather than.
Yeah, I don't necessarily, I don't have an objection to it, Ms. Thurston. Would you have an objection to that?
No, sir, I don't.
Thank you.
And I assume your client, Mr. Smith, are you okay with with your experts testifying remotely like we're doing now?
Yes, sir.
You would object to that, or you have no problem with that?
I have no problem with it.
Okay, so then I'm fine with it as well. And if there needs to be some tweaking of that date from the attorneys, moving it up or moving it back or whatever, you all can certainly call my office. But we'll do a status hearing on October 28th, just to make sure we're ready to go the next day. Okay?
Yes, sir.
All right. Anything else, counsel?
Nothing from the state.
Nothing from the defense, Your Honor. That's all I have before the court this morning. May I be excused?
You may be excused, and we are actually also finished with the morning docket. We still have the 11 o'clock docket. It's going to be a hybrid docket for those that will be appearing. I'm probably going to go into the courtroom because there will be some out of custody people that are showing out. I think there's about 4 or 5 out of custody people. Our court reporter will be on this. We'll be on this Zoom link, and if guys, whoever's talking needs to stop talking. Okay, mute. Okay, I will. If the attorneys that need to appear at arraignment can do so remotely as well, they're welcome to come to the courtroom. Maybe that the PDs may want to come in the courtroom because there may be a couple of their folks here, but I'll leave that up to the discretion of the attorneys. You can certainly appear remotely as well. Okay.